Today we're going to be speaking about revocable trusts. It's really going to be a very basic overview on revocable trusts because we're going to have additional webinars throughout the next month that will deal with more complex trusts and more details. But today what I wanted to do is just kind of give an overview. We're going to talk about trust basics, the difference between a revocable and an irrevocable trust, what the purposes of the revocable trusts are, provisions that I would recommend be in it, why it's important to fund the trust, and lastly, because it's a revocable trust, how do you actually revoke the trust? Let's go over a few definitions first. So firstly, what is a trust? And I get asked this all the time. A trust is really just a creation of a relationship, and it's manifested by a document. So the document that we create is a document that outlines what is going to happen to the trust funds, so the money that's put in the trust, and who are the parties involved. So the parties that we start with are the settlor or the grantor, sometimes but not often referred to as a trustor or a donor. That's the person that actually creates the trust. They then empower a trustee, and the trustee is the person, or could be a corporate trustee, that actually manages the trust property and makes distributions. And lastly, there's a beneficiary, can be one or more beneficiaries. Those are the people that are entitled to whatever the assets are of the trust. The assets of the trust really could be anything. A trust can be set up for any legal purpose, and it can really hold any type of asset. It can be real estate, it could be an interest in a company, it could be money, it could be tangible personal property like furniture, furnishings, paintings, etc., etc. There's really no limitation as to what property can go into a trust. And then lastly, and the reason I put this in here, principal and income, is that when a trust is created, it really has two parts to it. Sometimes it's the same beneficiary that receives both, but other times there's a split between who gets principal and who gets income. So the principal of the trust is the money that actually sits there, and therefore property that actually sits there and earns income. The income is the interest or the rental income or whatever money the trust throws off in a given year, that's the income. So when you're determining who your beneficiaries are, sometimes what we do is we have to partition off who's getting principal and who's getting income. So I think it's important for us to identify those terms. So let's talk specifically about the revocable trust. You've probably heard it referenced as an inter vivos trust, and that's just a Latin term which says during life. So a revocable inter vivos trust is one that is created during life. Now you cannot create a revocable trust after death because obviously you need to be able to revoke it, and only the grantor can revoke it, and after the grantor's death it would be irrevocable. So we have our grantor creates this revocable trust. And when that trust is going to terminate is all going to be dependent upon the terms of the trust that the grantor puts into it. The good news is if a grantor does the trust today and in 5 years decides either they're not happy with the beneficiaries or they want to change the way the beneficiaries are going to get money or any other terms of the trust, the grantor is permitted to amend that trust to make changes. And if the grantor determines that he no longer wants the trust, can actually terminate it. That's definitely one of the benefits of having the revocable trust. We're going to talk about what the purposes are of a trust, but one of the main things with a trust is it'll avoid probate. Just the 2-second synopsis on probate, that's the court process that's necessary to transfer assets that are owned by an individual who passes away. So if you own something individually, meaning it's in your name, it does not have a designated beneficiary on it, so not like a life insurance policy or an IRA, it doesn't have a joint owner with right of survivorship, then that asset, in order to transfer from a deceased person's individual name, needs to follow a court process to get from the deceased, from their estate, into the new owner's name. When assets are owned in a trust, they avoid that court process. And lastly, what I think it's important to point out, considering our firm focuses on asset protection, is that with a revocable trust, because the grantor has the ability to revoke and change that trust, there is no creditor protection inside that trust. That doesn't mean that the revocable trust can't be hooked up to other creditor protected entities. In fact, that's really the best way to go, to integrate your estate plan with your asset protection plan. But it's critical to note, because we hear this all the time, that revocable trusts in and of themselves provide no creditor protection to the grantor. We'll talk a bit later about where they can get creditor protection, but it's never for the grantor. I want to contrast the revocable trust with the irrevocable trust, and I'm going to just touch briefly on this because it's an important distinction. The irrevocable trust will also determine where your assets are going to go when you pass away, so that's no different than the revocable trust. The irrevocable trust can be created during your lifetime, or it can be triggered as a trust to be created at death, which we call a testamentary trust. The irrevocable trust cannot be modified or changed, except under certain circumstances where you empower what we call a trust protector or a trusted advisor who is given certain powers under the irrevocable trust and might be able to make some changes. But the grantor cannot make those changes. The irrevocable trust also avoids probate. And most importantly, if set up correctly, the irrevocable trust can be creditor protection for all the beneficiaries as well as the grantor. And what I mean by that is that if a grantor sets up an irrevocable trust, transfers assets into the trust, does not retain any beneficial interest and probably not any control, although that's a debatable issue, then if a creditor comes looking and sees that the grantor has set up this irrevocable trust, generally the creditor cannot get at the assets of that trust. Again, that's a subject for a later webinar, but it's important to understand the difference between the irrevocable and the revocable trust. And lastly, the irrevocable trust has certain tax advantages in terms of estate and gift tax, where if the irrevocable trust is set up properly, then assets that build in the irrevocable trust are outside of the estate of the grantor or settlor. Whereas with a revocable trust, all assets that are in the revocable trust are included for estate tax purposes in the grantor's estate when they die. So why would you set up a revocable trust? Number one, it allows you to set up provisions for your beneficiaries, for people that are going to inherit after you pass away. And it allows you to set it up in such a way that you can protect them. So if I create a trust and I leave my children as the beneficiaries for after I die, there are different methods that I can use. We're going to talk about different distribution strategies that you can use. But the idea is I want to provide for them. I don't usually want to just let them have the money. I want the money to be able to work for them and maybe have somebody manage that money and pay that money out as it's needed, not just throw it in their pocket so they can use it for whatever they want. My goal would be to provide for their future only for what's necessary and to protect them as beneficiaries either from creditors or from their own stupidity or being spendthrifts if they're not financially responsible. So the trust allows you to do that because the money is not in their pocket until the trustee distributes it. It allows for flexible distribution. So whereas in a will you would generally set it up and say, okay, when I die, my spouse will get it. After my spouse dies, the children will get it. If my children predecease me, their children will get it. That's great, but it doesn't really make any flexibility. It just says, okay, I die and it's just going to go into their bank accounts. It doesn't allow for seeing who needs the money more than somebody else. It doesn't allow for leaving the money to play out over time so that it doesn't go to them at one time, which can ultimately be a disaster. They use up all that money in a few months and then it's gone. With a revocable trust, you can create up and have the flexibility to distribute the assets under certain circumstances, or leave the trustee with control. We'll talk about that when we talk about discretionary distributions. Leave the trustee in control as to how those assets are distributed. From a grantor-settler perspective, being the grantor-settler is the initial beneficiary while that grantor-settler is alive. In the event that a grantor-settler becomes incapacitated and no longer able to manage their funds, whether it's a physical or a mental incapacity, they already have the money in trust. All that happens is a successor trustee, which the grantor has already named, takes over and manages the assets for the benefit of the grantor while the grantor is alive, whether it's paying the bills, putting them in a nursing home, making sure that their properties are cared for, making sure their business is cared for. It's much easier to do it that way than to rely upon a durable power of attorney, which you should absolutely have and very useful, and a healthcare surrogate. Great documents. Everyone should have them. But the trust allows for a much easier transition because they don't have to go out and start opening up accounts as a power of attorney or transferring property into another name because the property is owned by someone who's incapacitated. They don't have to get a guardianship appointed by the court because you can't transfer the real property without the guardianship sometimes. So it's very good if the settlor becomes incapacitated because it allows for a trustee with fairly seamlessly to take over and handle all of the assets just as if they were the settlor. And then when the settlor passes, that trustee is already in place and it's very quick and easy. The revocable trust, as I said before, avoids the probate process. But it only avoids the probate process for things that are transferred into the trust while the person is alive, while the grantor is alive. If they don't transfer it in while they're alive, then it's going to have to go through probate to ultimately get into the trust. We'll talk a little bit more about that when we talk about funding the trust. And lastly, with the revocable trust, while the assets that are in the trust are included in the estate tax, while they're included as part of the estate taxes for the settlor, meaning whatever I own in a revocable trust when I die, I'm going to pay estate taxes on it if my assets are above whatever the federal exemption is at the time. There are ways to structure the trusts that come after the revocable trust, meaning however things happen after I die, if I set up additional trusts to follow after I die, which is the general premise of these things, you can set it up with certain estate tax benefits for using an exemption that's available only to spouses and maybe using an exemption that's available for assets that skip a generation. We call that generation skipping transfer. So there are certain estate tax benefits that you can maneuver and use, but it's not for the grantor themselves. And I think that's very important to understand because if you own it in a revocable trust, it is taxable upon your death. No avoiding that. It's only in an irrevocable trust where it's the potential that it's not taxable after your death. So when I build a trust, and that's really how I think of it, it's really like building a document. What do I like to put in there? Well, what's very critical before you even get to who the beneficiaries are who's in charge. So that's the trustees. Now, in a revocable trust, you as the grantor are going to be the trustee while you are alive and while you are capable. After your death or incapacity, you have a successor trustee, one or more successor trustees, and those people take over. You usually have, if you can think of a number of people, that's great. You can have as long a succession line as you want. And then if you run out of people, there's a mechanism that we build into the trust to determine how another trustee can be empowered. And that's really important. You don't want to leave a trust with no way to get a new trustee if there's no one acting, because then you have to go to court and ask the court to appoint one. The whole purpose of these trusts is to avoid court intervention in everything. So if you set it up correctly and you put the proper mechanisms in place, then there should be no need to have a court involved at all. The trustee, it's a very personal decision as to who you choose. And I get asked this all the time. Who should be the trustee? Should it be family? Should it be non-family? There's really no right or wrong answer. It's going to come down to what your goals are, who is in your family, if there are appropriate choices. And sometimes I always suggest maybe you do two trustees. Maybe we do what we call co-trustees, where we choose a family member or a close friend, and we choose somebody that we call an independent trustee, someone who's not related. It could be a corporate trustee like a bank, like it could be Merrill Lynch, it could be Bank of America, it could be any one of those, or it could be a trusted lawyer or a CPA or somebody who you feel makes good decisions. But the key is you have to determine it based on what are their roles going to be. Are they going to be making immediate distributions? Or are they going to have to keep the trust going for a long period of time? What kind of beneficiaries do you have? Are those beneficiaries the kind that are going to need a lot of hand-holding? Are those beneficiaries the kind that the trustee is going to have to make sure what their situation is at the time, what's their financial situation, what's their marital situation? So a lot of it is going to come down to what's the ultimate goal behind the trust. Is the ultimate goal for the trust to just distribute at your death, in which case the trustee position doesn't really last very long, it's not such a big deal, the successor trustee? Or is it to have that trust last for as long as possible so they could pay out over time to as many beneficiaries as possible and last and be a long legacy? So choosing that trustee is a critical element of the trust, but it always depends on what the ultimate goals are. As I said, I often like to do a co-trustee situation where you do have a family member and someone who's familiar with the beneficiaries and who can be on top of them and be in touch with them and knows any of the emotional drama that's going on in the family. And then an independent trustee who could kind of be somebody who looks in from the outside, who might be able to make more unemotional decisions with regard to the money. And there are some tax reasons why you'd want the independent trustee as well, a little beyond today's scope. We'll talk about that when I do a webinar on irrevocable trusts. So first we have our trustee. After we have our trustee, we have our beneficiaries. Who do we want to inherit our estate when we die? Do we want it just to go to our children and our spouse, or do we want it to last longer? Do we want it to go into multiple generations? Do we want to involve charities? Do we want to create some sort of charitable legacy? Do we want to be able to change those beneficiaries? Maybe we put in a trust protector who I talked about earlier and give them parameters where they can actually manipulate the beneficiaries. The whole key with the trust is you can build it really customized. So all these decisions need to be made. The good news is in a revocable trust, if you make those decisions today and you later decide to change your mind, That's okay too, because as long as you have competence, you can change it. And if you don't have competence, if you have a durable power of attorney and you were confident in who you named as your agent under the power of attorney, you might have given that person the power to change the trust ultimately. I would tell you that most of my clients don't usually empower the agent under the power of attorney to do that, but some do. It is a possibility you can give your agent that power, that they can do that after you become incapacitated. It's a judgment call. You have to decide if, not just do you trust your agent, but are you comfortable with that idea? Here's the most important part that I think people don't necessarily always look at, and it's the distributions. It's not really how much the beneficiaries are getting, but it's how are they getting that money. Remember we talked about principal and income. So the income was what does the trust earn in a given year. You can create a structure where one or more beneficiaries are entitled to the income and the other beneficiaries are entitled to the principal, either simultaneously, or you can have just an income beneficiary until that person passes, and then the principal could be distributed later on. The mandatory versus discretionary is where I like to look at it from the asset protection standpoint as to this having a huge value. The old trusts used to say that when the grantor died, the spouse would have access to everything, and then at the spouse's death, the money would be given to the kids at a third at age 25, half the balance at age 30, and then the final balance at age 35. That was a pretty common situation. We did it that way in the 90s all the time. Very common. I still see it sometimes, but it's becoming less common. Here's my reasoning. If a beneficiary is going to get assets at age 25, 30, and 35, then great. The money will sit in until such period of time, but at that age the trustee has to distribute. Well, what if the beneficiary has a creditor? What if the beneficiary is in a bad marriage? Well, the trustee doesn't have a choice. The document says trustee has to distribute. So if I'm the trustee, it doesn't really matter what's happening with the beneficiary. I don't have options. If I'm the beneficiary, I'm saying, wait a minute, I don't want you to give me the money. But there's really nothing that can be done. So if instead of making that, which is what I like to call a mandatory distribution, the trust instead says that the trustee has the discretion to distribute a third of the principal of the beneficiary's trust when they turn 25, has the discretion to distribute half the balance when they turn 30, and the discretion to distribute the balance at age 35 and terminate the trust, that's a whole different scenario. Then it's completely up to the trustee whether or not they make those distributions. So that's probably the most cut and dry version of this. Somewhere in between is giving the trustee the ability, either mandatory or discretionary, to distribute for things like health, education, maintenance, and support. I still think that it's better to make it discretionary and not make it mandatory, because if I have a mandatory requirement as a trustee to distribute for a beneficiary's health, well then don't I have to pay any of their health bills that come due? We all know that if a creditor, if a healthcare provider is owed money, very often they can be negotiated with, but if there's a trust that they know about and the trust has to pay it, well then why would they even negotiate? So you have to be very careful with the provisions that you put in these things, which is why I always like the idea of the discretion. There doesn't seem to be a downside to discretion for health, education, maintenance, and support. And then depending on what kind of trustee you have, you can really make it discretionary for any purpose. Not with a family trustee, but as long as you have an independent trustee, they can have discretion for any purpose. So from a straight estate planning point of view, Either the mandatory or the discretionary is fine. It accomplishes the goal. But the discretionary definitely allows for long-term planning. It allows for distributions to go into multiple generations and for a legacy to really be established for your descendants. So I definitely lean towards the discretionary. However, if a client comes in and they say they want to make it mandatory, they want to keep things simple, because it is definitely more simple to do the mandatory, I can only educate and do what they want. So if you want simple, mandatory is probably the way to go. If you want more protective and a longer legacy, then discretionary is the way to go. We also put in what's called a spendthrift provision in the trust. This does not apply to the grantor, because as I said, there's no creditor protection for the grantor in a revocable trust, but it can apply to the beneficiaries. It basically says that a beneficiary has no right to use the trust funds as collateral for any debts that they may have, and it basically allows that no creditor can attach the trust on behalf of the beneficiary. With that said, if a mandatory distribution is due, the creditor can attach the mandatory distribution as soon as it's due. They can't attach it when the beneficiary is 24, but the minute they hit 25, if that was supposed to come out, then it's attachable. So a spendthrift provision should be in absolutely every trust. There's no excuse for it not to be there, but it only goes so far as non-mandatory distributions. If it's due out, then a creditor can get it, because it's as if it was already paid. Trustee powers, you can see that in one paragraph. You can see it in 15 pages. I've seen it all. Trustee powers are things like ability to sell assets of the trust, ability to take mortgages out, rent out assets, open bank accounts on behalf of the trust, buy new securities. It can be broken down into minute detail, or it could be extremely broad. It's completely up to the drafter of the trust as to how long they want to make a trust. I can tell you that the shortest revocable trust I've ever seen was 3 pages, and the longest one was 102. And I don't know that there was a huge amount of difference between the two of them, other than the fact that there were a lot more detailed provisions in the 102-page trust. Now, a 3-page trust is really fairly inadequate, but let me compare it with, let's say, a 10 or a 12-page trust. It's just a lot more detail. If you're going to do mandatory payouts at a certain age, well, then you could probably get away with a small trust. But if you're going to do it more discretionary, then normally your trust is going to be somewhere between 25 and 35 pages. And yes, it's a lot of words, but the more detail that you put in, it gives more direction to the trustee. So it's not a bad idea. I think 100 pages is a little bit over the top, but that was what that particular law firm was doing. Trust protector, I've mentioned already a few times during today's webinar. A trust protector is someone that you can put in a position, either as a fiduciary or a non-fiduciary, to be able to make certain changes to an irrevocable trust. The reason I talk about it with regard to a revocable trust is, while you're creating the trust will ultimately become irrevocable, and that's when the trust protector's powers kick in. So you have to talk about it with regard to a revocable trust, because I have to be able to put that power in there. And what we do is we empower this person to be able to change the trust if, let's say, the tax laws change and now the trust is irrevocable, and there's some benefits that can be had if the trust is changed for tax purposes. What if there were typos that make significant difference? The trust protector could change those as well. Sometimes we have the trust protector being able to remove and replace a trustee other than the grantor. We can have the trust protector be able to change beneficiaries among a certain class of beneficiaries. So for instance, let's say you've left everything to your descendants and the trust is going to keep going for a while. Well, what if some of those descendants turn out to be either not very good people, criminals, or they're so wealthy that they don't need the money? Well, a trust protector can kind of shift away the assets from those beneficiaries who either don't need it or don't deserve it. So we can have a trust protector also monitor, be like a second checks and balances system over the trustee. They can be required to approve of investments for the trust. So there's a lot of flexibility that can be provided with a trust protector. So I always suggest putting in the provision. If you can't think of who that person would be, that's okay, because we can put in a mechanism, just like with the trustee, to be able to choose that trust protector later on. But if we don't include the trust protector language, then later on they're not going to be able to change it after your death. And there's a lot of other provisions that would go into a trust. For instance, we put in provisions about disclaimers, what happens if a beneficiary chooses not to accept what's given to them under the trust for any different reasons. We want to say what happens to the asset if it doesn't go to that beneficiary. You want to have a backup plan. We put in provisions regarding subchapter S corporations, because only certain trusts with certain provisions are able to hold S Corp shares or LLCs taxed as S Corps. I like to put in provisions, specific carve-out provisions that we're going to talk about in a moment. For instance, we're going to talk about the mandatory trust provisions, which I talked about earlier, and that requires payment. So as I said, if the trust says the beneficiary has to get something at a certain time, that has to be distributed out. Whether it's certain ages or upon certain events, the beneficiary gets money upon graduation, money towards a wedding, if they have a child, if they want to buy into a business or create their own business, if they want a down payment on a home. These are all things that can be built into a trust, whether it's mandatory or discretionary. But these are things that if it says that the beneficiary has to receive it, then they do need to be paid out. So what I usually like to do is put in these provisions, but put it in on a discretionary scale. For instance, if the beneficiary is getting married for the first time, then the trustee should be permitted the discretion to contribute to the wedding of the child. I usually like to put in a certain number just so that it doesn't get out of hand. It's very hard for people to come up with that number, but we sit down and we just kind of flesh it out and make a decision as to what they think would be reasonable, and we may put in a provision inside the trust that allows everything to be increased based on inflation. Business, the buying in or creating of a business. I always put a clarification in there that it's not a random situation. Beneficiary can't just go to the trustee and say, hey, I want to create this business, give me money. Well, no, even if it's a mandatory provision where the trustee has to give the beneficiary money, the beneficiary has to present some sort of business plan in order to get that money. So that's if it's mandatory or it's discretionary. And often we'll put a cap on that as well, indexed for inflation. Down payment on a home. I never really think that a trust should pay for an entire property for someone, although some people want that. My feeling is that if you have the trust pay for a down payment, let's say 20%, then whatever the beneficiary has to come up with on their own or in a mortgage, they'll be able to afford. If you allow the trust to be able to just pay any amount, then the beneficiary may bite off more than they can chew and buy a piece of property that they can't afford. But if they are only getting a down payment, then a beneficiary who's earning a good salary and has a lot of income coming in will theoretically be able to buy a bigger home and get more out of their trust for a down payment than the beneficiary who's only making a modest income. And this way it controls that the beneficiaries don't get in over their head. As we talked about earlier with the mandatory distributions, there's no creditor protection for the beneficiaries once that payment is due. But the trust provisions and the trust itself, when it's mandatory, are simpler to administer because chances are the trust is not going to last as long, because if everything is being paid out on a mandatory basis, it's going to end. One thing I didn't discuss, and I'll discuss briefly, is how long can a trust continue? That depends on the state that you're in. Some states have a rule, it's a very old rule, that says that a trust will only be viable and can only stand for life and being plus 21 years, which basically doesn't give a huge amount of time. And it's life and being at the time that the trust was created. So it doesn't give a huge amount of time. Places like Florida have 360 years can be the cap, which is many, many generations. There's other states where it can go dynasty trusts, where it can go forever. But majority of the states are somewhere between the life and being plus 21 and 360 years. So based on your state statute, you have to be able to really kind of look at the big picture and see how long you want your trust to last. To contrast the mandatory provisions, we have the discretionary trust provisions. As I said earlier, those will allow for creditor protection for the beneficiaries. So how does this work? Let's say I have a beneficiary. We have discretionary trust provisions. So the trustee has the discretion to determine if and when to make the distributions to any of the beneficiaries. Well, if a beneficiary is going through a divorce, we don't want to put any money in their hands, because then it becomes a potential marital asset, and it's possibly going to go to the ex-spouse, or it can be used in the calculation of child support and alimony. I will tell you that most state laws allow for trusts to be broken into for alimony or for child support. Mostly for child support, some for alimony. So you have to be very careful if a beneficiary has any sort of mandatory distributions, the trust can be attached. If it's discretionary, then it's much more difficult. It's not an absolute guarantee, but it's much more difficult for that to be broken into, even for those types of things. Under the discretionary trust, the trustee has a lot more control, which you may or may not want, and that's a lot of reason that some people don't do a discretionary trust. But if you give the trustee the control, then the trustee can really monitor the situation and give only to those beneficiaries what they need and what the trustee feels they can handle. Keep in mind that the trustee doesn't necessarily have to pay and give the money to the beneficiary directly. A well-written trust is going to allow the trustee to pay money on behalf of the beneficiary, maybe pay bills. So it could take the spendthrift problems out of the beneficiary's hands if they have financial problems, if they tend not to be responsible for money. The trustee can also essentially take some control over the beneficiary's behavior, because if a beneficiary knows that the trustee is in control and the beneficiary is not going to get money if they behave poorly, then the trustee really controls that beneficiary's behavior, because the beneficiary has no choice. If they want money, they've got to toe the line, and if the beneficiary doesn't toe the line, the trustee is not giving them any money. So it does give some control. And one thing that's very important, it's an income tax situation, is let's say you have a trust and the trustee has the discretion to sprinkle the income among the beneficiaries, which means that the trustee can give all to one person or split it up any way the trustee wants. That's good for the beneficiaries too, because if a beneficiary has enough independent wealth, they may not want the income from the trust. If they get the income from the trust, they're going to pay income tax on it. So if the trustee has the discretion to be able to sprinkle that among the beneficiaries, then he can sprinkle it out and send it to those who have lower tax brackets and probably need it more. So that's one of the very good benefits of a discretionary trust. And finally, as I discussed earlier, a discretionary trust can last longer because if you're not paying out mandatory distributions, there's likely to be more money left for future generations, assuming the laws of that state allow for the trust to exist for a longer period. Funding the trust, especially the revocable trust, is very important. I can't tell you how many people create revocable trusts and then usually they're not my clients, although I'm sure my clients have done it too. They leave the lawyer's office and then they never do anything. They just have this trust, which is all well and good because when they die, their assets will ultimately go where they wanted it to go, discretionary, mandatory, however they set the trust up. The problem is if they didn't fund the trust during their life, then the only way to get the money into the trust is to get it through probate and then put it into the trust. So that's an important step that they could have eliminated if they funded the trust themselves. In addition, if they don't fund the trust, then they're not thinking about things that have beneficiaries on them. Meaning if I have a life insurance policy, life insurance doesn't usually go through probate because it has a beneficiary listed. But if I have money from the life insurance going to an individual beneficiary rather than going to the trust, then all the money in the life insurance policy doesn't get distributed the way I would expect that the trust would be distributed. So you could have a complete inequality among the beneficiaries if you don't make sure that everything is structured the way it's supposed to be structured. And you've got to do that during your life so that it goes exactly the way you want it to go at death. In addition, you don't avoid probate, but if the grantor becomes incapacitated and they haven't funded the trust, then unless their power of attorney is able to fund the trust, then now you have an issue where how is the settlor who's incapacitated going to survive? We may need to get a guardian appointed for them by the court. It's very costly. It's very restrictive. Not really the best way to go. So funding that revocable trust is really, really important. And the last thing I want to talk about is because it is a revocable trust, it means that the grantor has the ability to get rid of it if they want it or to change it. If they want to change the trust, it's called an amendment, and they go to their attorney and they tell their attorney, okay, here are the things that I want to change, and the attorney can make a simple amendment if it's possible, or if it's going to be really a change of majority of the trust, then what the attorney will do is do what's called an amendment and restatement, which basically means rewrite the whole trust, but use the original trust name and the original trust date as the reference. So you keep a copy of the old trust, but the new trust is really just a revamp of the old trust. That's if you want to amend it. And you still have to have witnesses and a notary, depending on what state you're signing in as to what the formalities are in the trust for signing it. If you revoke a trust, which means you say, oh, I don't really want it anymore, it doesn't happen very often, but I've seen it a couple of times in my career. When you revoke a trust, then you've got to do it with the same execution requirements, again, with the signatures of the grantor, the witnesses, the notary, and of course the trustee has to sign. Now, 99.9% of the time, the trustee is the settlor, so it's not an issue. But on a rare occasion where there's either a co-trustee or the settlor chose to have somebody else act as trustee, I think I've seen that once, then that trustee has to sign. But the key is that if you're going to revoke your trust, you have to make sure to empty it. For instance, if you own a piece of real estate and it's in the trust and you revoke the trust, well, there's nobody now to sign to do anything with that real estate. It's a huge problem. It's going to be a title nightmare. So make sure before you ever revoke a trust that you are 100% certain that everything is outside of the trust, which is why most people don't revoke. You can create a new one if you really want, or do an amended and restated one, however you want to do it. But if you revoke it, you do run the risk that there was an asset in there, and someday that's going to be a problem when someone tries to get that asset, a beneficiary, and there's nobody to be able to sign for it because there's no trustee, because the trust itself is no longer viable. So you can revoke a revocable trust, you just have to be extremely careful. And once it becomes irrevocable, meaning after your death, or if for some reason you choose to make the trust irrevocable, then that's it. You can't revoke it any longer. I want to thank everybody for joining us today. If you have any questions from today's webinar, please make sure to email them in. If you're not already on our newsletter, please make sure you contact us and we'll be happy to put you on there. And if you're interested in any of the topics we talked about today or any other topics regarding estate planning or asset protection, then please let us know and we'll be happy to set you up with a complimentary preliminary consultation. In addition, if you have any webinar topics, things that you'd like to hear about, we're always open to those. And just contact, you'll see there's a contact at the end for sb@assetprotectionattorneys.com. Thank you all for joining us, and I hope you'll join us for our next webinar. Thank you.